He is an experienced trial lawyer, an experienced capital litigator for the state. Don't tell me that these words weren't carefully chosen by him. I don't believe that.
And the other thing that struck me about this case is this is just a perfect example. So he is considered a serial killer as far as 5 different victims, but also just what a normal guy everybody thought he was.
Is not allowed to be seen by the jury. Summer's over. Kids are back at school. And here we are.
Sure still feels like
cutting another episode. Well, it's hot. I think today's supposed to be 117 degrees outside.
Like, that's real.
Yeah, although I did have an opportunity to visit the Midwest it was about 2 weeks ago. Went to Indiana, Louisville, Cincinnati area, and it was not as hot, but super humid. You walk outside and you're just sweaty, right?
We're not used to it. It's dry heat is a real thing.
I know. And so I had the opportunity to compare the two, and I'll tell you what, I'll take this any day.
Yeah.
That Midwest heat is terrible. Sorry to all of our Midwestern listeners.
I know we've got a ton.
huge following in the Midwest. Well, we got another case to talk about today.
Speaking of, this guy comes from
Oklahoma.
Really kind of south, I guess.
Well, he was born in Oklahoma.
Yeah, Oklahoma City, right?
Yeah.
Yeah, an interesting one, and we can start with the name, right? Yeah. They call him the Crackhead Killer, which I hate.
I don't love that.
I hate that name, and it's that they come up with these names. Really, it's the media, I think.
Sure.
Right. Sometimes it's the police because they're trying to.
Right.
I don't know, but it's probably the media in this one, and I hate it so much because it's not referring to him or how he did his murders.
Yeah, he wasn't the crackhead.
Yeah, they're saying that's what they're calling the victims,
right?
In this case, they call it the crackhead because they were generally addicted to drugs.
Yeah, this one was a tough one. I said this earlier during our kind of show prep that we do. It's a sad case.
Yeah,
it's a sad case of multiple homicides. What I consider to be a sad defendant. The killer, Mr. Morris. We're calling him Cory Morris is his name. But the guy accused of these murders, I think he had a pretty sad life. Not that justifies his actions. Of course, it does not.
Yeah.
But it's something that kind of struck me.
Yeah, and the other thing that struck me about this case is this is just a perfect example. So he is kind of a classic serial killer. Like, he is considered a serial killer as far as 5 different victims, 5 different dates with a cool down period in between, kind of a method, things like that. But also just what a normal guy everybody thought he was. So yeah, born in Oklahoma City, 1979.
Yeah, that's our age. 78. Yeah,
and was in ROTC in high school. Went to high school out there. Came out to Arizona. He was pretty young, 22 years old. I was able to hear some interview with his employer. Mm-hmm. He worked at he ran the karaoke stand at the bar,
mm-hmm.
which was pretty popular, and everybody really liked him. His nickname was Huggy Bear. Big guy, and just a lovable guy that people really liked. He was friends with multiple people, and just that was her takeaway is I could know and like this person who turns out to be accused of these terrible things. I think if we're going to go back to the name on this one, I would name this one, and maybe a better, more clever way to think of it, but the Stinky Killer. Right?
Yeah, because the scent is really what got him into trouble, right?
So interesting, right? So I guess setting the stage on this as far as how initially police came into contact with him. So he was living, when he moved to Arizona, living in a trailer in his aunt and uncle's backyard. Or property. I'm not sure how big the property was.
And this was in Central Phoenix, kind of in the middle of downtown Phoenix.
Yeah. And, he, again, this is attested to by his employer, who said, over time, it was noticeable that he had a pretty bad body odor, really distinct. It got to the point where she said, we would sit down with him at a restaurant and we would all kind of, scoot around to sit somewhere else because it was stinging. It was really bad, and it was just getting worse. And so apparently his uncle had decided, I gotta go talk to Cory about how bad he smells and see what we can do. Figure this out. He goes out to the trailer. He can see that there's a bunch of flies. He smells that it is just rotten. And so he opens the trailer door. This is gruesome. Goes inside and just sees maggots coming on the ground and flies to where he said that the ground was boiling. That's what it appeared to be.
Awful.
He lifts the blanket, and there is a dead body there with maggots, everything. Obviously has been there a while with a sheet over it. He obviously leaves, calls police, and that's kind of how he starts getting tied to multiple murders, which turned out to be like less than 100 feet away. I mean, as far as where the other bodies were found,
Right.
And we'll get into that a little bit.
Right. That's how the investigation started. And just to fill in some detail, that was April 12th, 2003, when the uncle goes out to the camper and he finds this body. The body had apparently been there for several days. It had an awful smell to it, an odor to it.
Medical examiner estimates 3 to 7 days.
Yeah. And then there were a number of other, at that point, unsolved homicides that had occurred in the months leading up to that April 2003 discovery.
Homicides and deaths that hadn't really been determined how they died because of the level of decomposition of the bodies.
Yeah, do you want to walk us through briefly?
Yeah, so let's, I guess, talk through, do you want to talk through kind of each of the victims? I have just a really brief. We don't want to spend too much time on it. It's just kind of a brief. We obviously want to be respectful, but give you enough factual piece of it. Also to understand, this happened really in a short period of time, really a prolific set of murders.
Yes, 5 murders in the span of 6 or 7 months.
7 to 8 months.
Yeah.
So you've got September 2002. And again, it's hard to know the order to do this.
That's Barbara Codman.
Barbara Codman.
Okay. So she's found in an alley near McKinley and Pierce Street, which is just barely north of where he was living in this trailer.
Right there.
And again, her body was, found there in this alleyway, decomposing, no clothes on, which is kind of the pattern that we see for the remainder of.
Yeah, Shantaria Davis is number 2. So first one September 2002, second one October 2002.
Again, that woman's body is found in that same alley. There's drag marks. There's obviously decomposition of that flesh, and just in awful condition is what they find the body in.
And the drag marks go, pretty much right to the property.
Right.
Where
not very far away.
Yeah.
The next one is February 27th, 2003. They discover the body. This one's clothed, of Jade Velasquez on the west side of 9th Street, just outside of the gate leading to where his camper was. Right
the
there.
Gate to his
right
yard.
There.
And I saw some stuff too where they talked about that you could tell they could tell there'd been disruption to that area. Potentially the gate had been replaced.
Right.
And they
The
did
door had
talk.
come off
And
the
they did
hinges
talk
or
to his aunt.
Right.
About that. They were right there.
Yeah, and it's a little surprising that police hadn't started asking questions in the neighborhood. Hey, what's going on with the women that we see here, or these these deaths that have been unexplained.
And I need to get clear on which ones are which, but I know that for a couple, and I believe it was 2 of these. It was either Jade and Shantaria or Barbara, 2 of those. They had actually determined that they had overdosed.
Right. So 2 of them had a cause of death that had been determined by the medical examiner to be drug overdose. Right.
Right. And again, it was because of the level of decomposition of the bodies.
But they were still able to do the toxicology and find that these things were in their systems at the time of their deaths.
And that's interesting. I found that interesting.
It really is. And you can still, that evidence is somehow preserved enough
a week or 2 later to be able to tell what they even talk about the blood alcohol concentration.
Yeah, and it was still fairly high.
Yeah.
So then another one is March 29th, 2003. Police found Sharon Noah's naked body on the west side of 9th Street, approximately 15 to 20 feet from where Velasquez's body was. And hers was just outside of the gate. So go another 15, 20 feet from the gate, and this woman's body is found.
And then Julie Castillo is the final one, who was the actual one that was found in the trailer.
In the camper, yeah. So a total of 5 women, all found either in or near his residence, and all very decomposed, some naked, and just the proximity of these is just astonishing how close they were.
And I don't want to misspeak. I believe they all had some connection to being sex workers in one way or another. I know one of them, as far as how the facts came out, it wasn't totally clear to me if that's what her...
Well, Morris, we'll get into his statements here in a second. Miss Castillo's body is found, Julie Castillo is found in that April 12th, 2003 search of his camper, of course, by the uncle. Morris is then arrested, and he's questioned by police. And it's interesting, the evidence that came out at the trial, so he's arrested. A grand jury eventually indicts him for these counts. And of course, leading up to that investigation, or during that investigation, he's questioned by police. And he gives a couple of different versions. I'm not going to attach each of the details to each of the murders.
Because they're really all the same.
They're really kind of all the same
similar
in terms of how he explains it. His general explanation was, at first, he had paid the women to have sex with him. Then they wanted to do drugs. He left them alone in his camper to do drugs. And then they died. Okay.
He comes back and they're dead 5 times.
5 times. And then the other version, and I'm generalizing these, but essentially the other version is they had agreed to have sex with him, and that he had, during the course of that interaction, choked them, and they accidentally died.
And they all say that they wanted him to...
Correct. At their request.
His version of the facts.
Correct.
And begs the question, if you've accidentally strangled 4 people during sex, maybe...
Right, it starts to...
It's not accidental anymore.
It raises some red flags.
So, yeah, it was interesting, too. We talked about, when we were kind of just spitballing about the case, it's just such a great example of, we'll talk about the trial and how it was just what are you going to do as a defense attorney in this case?
Tough case to try.
But the fact that he had walked in, and it appears from the state, from the case documents, that he had made both of these statements in the same sit down with the detectives, and it's just such an example of, gosh, maybe he was going to get convicted anyway, probably in this case, regardless. But the fact that he had some of these statements really came back to bite him, especially on, we've talked about this before, the aggravation phase of the case, when the jury decides whether or not it's life or whether or not it's capital murder or
right.
Death sentence.
Yeah, and I guess to clarify, this was seek the death penalty in this case. And so there was that guilt phase where they determine, is he guilty of all of each of these homicides? And then once guilt is determined, if there's a guilty verdict, then the jury has to decide, is there enough evidence to warrant the death penalty based on their weighing aggravating factors versus any mitigating factors?
Yeah, that's always an interesting process, right? You've got the guilt phase where some evidence is not admissible, but it will be admissible during the aggravation phase on what can come in. And that a jury a lot of times doesn't know during the guilt phase that they are now, once they're done with that, they think they're ready to go home.
Right.
Oh yeah, by the way, now we're going to talk about, in a capital case, it can take a long time, an aggravation phase where the prosecutor is going to put on more witnesses and talk about all the terrible things and why this qualifies. Because you have to, there's statutes that determine what you have to show in order for it to qualify as a death penalty case. It's not like you can just say, hey, this was really bad.
Right.
And so, most murder cases do not qualify as death penalty cases. So they have to then prove it. Then the defense can put on all kinds of what we call mitigation and say, here's why you should determine that it's not a death penalty. You should, and that's a difficult thing. We've talked about that before too. It's such a tough thing for kind of an everyday person to come in and just be asked to make that determination.
Yeah, it's a tough situation.
Yeah.
So we've laid out the basic facts. Because of sort of the gruesome nature of each of these murders, I don't think it's necessary for us to go into detail about each one of the bodies and so forth. But suffice it to say, you have these 5 homicides. You then now have his statements that he gives to police. One version where it's they died during a drug overdose. Another version was they accidentally died during this, a sexual interaction that each of them has. And so those are the essential facts for the case. Now he goes to trial. He's represented by a state-appointed attorney. And I'll give you one guess, but I'll give our viewers one guess. Who was the prosecutor in this case?
Yep.
Well, It was Juan Martinez.
Yeah.
This is another one of Juan Martinez's cases. And really, really interesting is one of the issues that's raised on appeal, of course, and maybe we start here, is, of course, prosecutorial misconduct.
Yep.
Wouldn't you know it, that Mr. Martinez gets accused again of really going too far in the case.
And it's not uncommon for that to be one of the bases.
Of course.
But when you read through it, usually it's like, that's BS. I mean, there's just not enough there. But when you read through a lot of these cases that Juan Martinez does, that he did, you look at it and say, he said what to a jury?
Almost every time does he get called out for crossing the line in some way or another. There were a couple of instances of misconduct that Morris's attorney on appeal alleged. And so let's dive into those a little bit. One of those was a statement to the jury. Now, this is during the aggravation phase. Now, you mentioned a little bit earlier that in order to qualify for the death penalty, there are certain statutory aggravators, things that the prosecutor has to prove to the jury that exist. Here, they were, number one, the multiple murders, okay? And that's sort of self-explanatory. You have 5 women who have been killed. But then you also have to show, and we've talked about this aggravator before, what's called the cruel, heinous, or depraved murder. The fact that there was suffering, that there was impending doom, that these women, each of them, went through prior to their actual deaths. And so what was called out by his lawyer in terms of what Martinez did in the trial occurred during that aggravation phase, where he tells the jury to put themselves in the position of the victims and imagine themselves being, crushed to death by Morris.
Yes. Imagine Cory Morris sitting on your chest.
And not only did he call out the jurors collectively, like, hey, put yourselves here, he says, Juror 1, Juror 14, how would you feel? And he did it specifically to women on the jury.
Because he didn't do this to guys.
Right.
He actually said he did this to women, so let's look at Juror 1 and Juror 4 because you're women.
Right.
I want you to think about what if you were in this position. And that might not sound that, outrageous to people. Maybe it does. But that's like a cardinal rule. Like, prosecutors you're not allowed to say, juror, put yourself in the shoes of the victim.
Yeah, and there's a little bit more leeway here because it was during the aggravation phase, and he has to prove cruel, heinous, and depraved. However, the way that he did it, specifically calling out particular jurors, hey, imagine him sitting on you, and he was a heavier guy.
How would you feel?
How would you feel, right? You can't do that. And so I want to quote the Supreme Court when they said that. Although the state argues that the prosecutor simply asked the jurors to apply common sense to the factual situation before them, the prosecutor's remarks did far more than make that request. Instead, the prosecutor singled out a particular jurors and addressed them personally, playing on their sympathy for the victims and fears of the defendant. And frankly, I think the court let him off a little lightly when they say such remarks constitute misconduct. Inserted the word gross misconduct or obvious misconduct or something to enhance that misconduct to where it's not just, average everyday misconduct. Okay, because an off-the-cuff statement by a prosecutor certainly may be misconduct. But this is Juan Martinez. He is an experienced trial lawyer, an experienced capital litigator for the state. Don't tell me that these words weren't carefully chosen by him. I don't believe that. And so when he comes off and he does stuff like this, it's a little bit frustrating that the court would say, that's everyday misconduct. But probably for him it was. I mean, he no longer practices law, so I can say that. Now, here's what kills me. So I'm not going to let off the defense attorney either. I'm not going to go easy on him either. Because in the very next sentence of the very next paragraph of the opinion, Morris's defense counsel did not object.
I mean, it was such an obvious objection.
You're sitting there listening to Martinez put these jurors in the place of the victims and engage in clear misconduct. And defense counsel sits there at the table and says nothing.
It's a bad.
That's appalling.
It's a bad. And the thing is we hate kind of like armchair quarterbacking.
Of course.
You know, trial defense attorneys is very difficult. But I mean, you go back to the beginning too, and it talks about, and it's just such an example of why it's so important that defense attorneys object appropriately. So
absolutely,
we talk about, you know, sometimes we have a client and we're in trial and we make an objection and it gets denied, right? And the judge says, denied, I'm going to let him go ahead and talk about this, right? And sometimes your client thinks, shoot, we just lost that. When half the time that is not necessarily the purpose of the objection, because this talks so clearly about, hey, here's this question that they brought up, the defense, as far as whether this was improper in the trial in some way, not just the prosecutorial misconduct, but other things that happened.
Any issue.
And they say, well, the defense attorney didn't object. So because they didn't object, we're going to use a different standard.
That's right.
To determine whether it's something that will overturn the case or that, you know, how seriously we're going to take it. So that can make all the difference in an appeal on whether or not you get a new trial, a conviction gets overturned, is because they were only looking at it if there was a, what did they call it?
Well, the standard is fundamental error.
Fundamental error.
And that's error that goes to the foundation of the case. And so it has to be, it's much more difficult to get a case or a verdict or a sentence overturned on appeal if there was no objection to whatever it was below at the trial level. The bar is set much higher if there's no objection. However, to your point earlier, if during the trial the lawyer says, I object to that, or they file a motion challenging something, or they do something in the record throughout the course of the case, including the trial, then that preserves the issue so that on appeal, the appellate counsel can then say, we were dissatisfied with this at the trial level, and that error continued up to the higher court. Therefore, the higher court, the Court of Appeals, does a much more full review of that proposed error, and it's easier to get things overturned. And so it's frustrating to you, it's frustrating to me when we sit here, and throughout the course of this entire opinion, it must say a dozen times, defense counsel failed to object.
So we're just going to look at it for fundamental error.
And that's frustrating because I think he does raise a valid claim of prosecutorial misconduct here. Is it enough to overturn the case? I don't know, but I think it would have been more thoroughly analyzed by the Court of Appeals had the lawyer at the counsel table have said, I object to Mr. Martinez's remarks, or he would have said, objection. I would have approached, Judge, that's misconduct. I want a mistrial. That's what I would have done.
Right.
Okay. You would have done the same. He didn't do that. And so Morris is left to just sort of make these sort of weak arguments on appeal about important things, but court ultimately says there's not enough there to turn it over for prosecutorial misconduct.
Yeah.
Now, there was another issue of prosecutorial misconduct.
The court goes on, too, to talk about misconduct. Did it change? You know, because it has a couple different standards they look at as far as whether it would potentially could have changed the verdict or the decision of the jury, and they decided that it didn't. But yeah, I do want to get to that.
There's two more. Okay, so one of them, I think, as again, armchair quarterback, I think was a sneaky move by Martinez. In any homicide, the court has to be careful about what types of photographs get admitted. Generally, overly gruesome and prejudicial photographs of dead bodies or carnage is not allowed to be seen by the jury. Yes, the state has the burden of proving a homicide, and yes, they have to show, the cause and manner of death and so forth and meet their burden. But you can't do it in a way that is so gruesome that it's just for show. You're just trying to make the jury have an emotional reaction to photos.
That's the purpose.
That's the purpose.
Is to say there's no other valid element to this crime that it's actually proving. It's just there to inflame the jury or make them sick or make them say, how could we ever let this monster go? And forget that they have to determine whether this guy actually did the crime.
So the court had previously excluded a particular photograph, I think one that was showing that sort of maggot infestation. It's gross to even think about, right? Nevertheless, Martinez has on his desk, his table in trial, the full picture
full
sitting
8x11, probably, you know, size of color,
sitting there on his desk.
And just for the, you know, for the audience, prosecutors sit next to the jury.
That's right.
So
the rule in Arizona is the prosecutor's table is always the one that's next to the jury
closer
box.
to the jury because, I don't know, they have the burden, I guess, is what I've always heard him say.
Right. So when you and I walk in a courtroom, I automatically know which court table or which counsel table to go to in a criminal case because I'm a defense lawyer. I don't go to the table next to the jury. I go to the one away from the jury. So to your point, Martinez's table is right next to the jury. He's got this 8.5 by 11 photograph of this that's been excluded by the court sitting just wide open on his table. Now, defense counsel amazingly objects to the photo.
That is like the one
right.
You got.
You know, so there's a record of it. But what the Court of Appeals, they resolved that by saying there's no evidence that the jury actually saw it or had any prejudice from it.
And that Martinez immediately complied as far as putting it away.
I'm sorry.
And there's no. Oh, I didn't realize.
Silly me. How would I have known to? Yeah. Come on. I'm not buying that.
And that, you know, he didn't do it again later in the trial. And we're going to talk about this in future cases that he has also done where he did the same thing. You know, this isn't just like a one-off situation.
I do not believe that was accidental. Yeah. But again, even together with his comment about the jurors and this other thing of misconduct that we'll talk about, the court finds that the prosecutorial misconduct was not enough to overturn the verdict. So the last thing, you want to talk about that one?
Yeah, we can. So the last one, and this was in the guilt phase, I believe, right? As far as the bag, the jacket, you check that for us.
I will.
But in another part of it, Juan Martinez is having, so the prosecutor is having the detective go through the evidence. And one of the pieces of evidence was a jacket that had been owned by one of the victims that was, I believe, in the trailer at the time.
It was during the guilt phase. So again, the jury still hasn't yet determined, is Cory Morris guilty of these murders? And tell us about the jacket.
So it's encased, right, in like a plastic evidence bag type of thing. And Mr. Martinez in trial says, will you go ahead and open that bag for us? He opens the bag and the smell is overpowering in the courtroom. And Mr. Martinez says, jury, this is for your smelling pleasure.
Yeah, and it, of course, reeked of that same or similar odor that Morris's coworkers and family complained of. And I think he wanted to, I guess, have them experience the same thing other people did. Now, is that evidence? Is it probative? Is it helpful? I think it does have a degree of value, but is the helpfulness outweighed by sort of that exaggeration, that prejudicial effect? And that's the balancing test that the court has to do, the trial court has to do with any piece of evidence. They have to look at the value of it versus the harm that it may cause. And I think the trial court should have not allowed him to do that.
And to bring that kind of smell portion of this case, we kind of started out saying that we think that should be the name of, or I think that should be the name of this case, is, when I heard this interview with his employer who had talked about his odor, this is where we come full circle on that, is they later learned that was his body odor, is that he was spending his time in his trailer with rotting corpses who had maggots, whatever, and that odor was attaching itself to him and his clothing, and that was what people were smelling on him.
Yeah, that's foul,
atrocious,
dead body odor. Just awful. Ugh, awful.
Yeah.
So, can you imagine why Martinez wants to do this? Yeah, he wants to just kind of show off a little bit, like show that he's got him, and have the jury be on his side, because how awful is that? How gruesome is that? How stinky is that?
It's gross.
It's awful.
Right? And it makes him a weirdo, and it makes him...
But is that how we want to present cases at trial? Again, it's hard to go back and armchair quarterback this and say, well, I would have done this or she should have done this differently. But I just think it's a little bit of a move by the prosecutor.
Oh, for sure. And it's tough, right? Because not that I'm here to defend the prosecutor, but you got to keep these things interesting. Prosecutors need to do that. Sometimes in trial, you'll see jurors falling asleep. I mean, the tediousness of going through evidence a lot of times is incredibly boring, and you gotta. He's trying to give him
You got
some
to
sizzle.
liven things up. This was a trial that was about 8 weeks long, and so sure, I mean, every day, it may seem to kind of just one day drags into the next, and so he spices it up a little bit with their smelling pleasure, or for their smelling pleasure. I think it's a stupid move by him, but hey,
Again,
he's Juan Martinez.
Again, Court of Appeals said that there was legitimate reasons.
Yeah, there's
for
a
that.
legitimate reason for it. Again, they do that balancing test. They say there is probative value. It's not substantially outweighed by unfair prejudice. Therefore, it's okay. But they did criticize his comment. They said he shouldn't have made that mark for their smelling pleasure. So they take all of those three allegations of misconduct, the sympathy of the jury by putting them in the shoes, the smelling coat or the jacket. Again, him playing off the sympathies of the jury and
The gruesome photo.
The photo that's on his desk.
Yeah.
That's right.
So
anyway, they take all of those three things and they say, even taken as a whole, those three things do not amount to misconduct.
there was actually one
Or
more,
enough misconduct to overturn the verdict. Go
one
ahead.
more, and maybe we discussed it and I just missed it.
Yeah.
Martinez is arguing that
All right.
that the reason he was doing this is he enjoyed sitting with these rotting corpses in his trailer, and that he used them to have sex with them after they were dead. In fact, when you look this case up, it'll say, convicted murderer and necrophile. So saying that he had sex with corpses when it wasn't really proven in the trial.
There wasn't direct evidence to show that occurred. However, what the court's response to that is, it was in a closing argument. It was a fact that was reasonably inferred or inferable from the evidence that was presented, and that he didn't stray too far from that proof. And so the court says, yeah, prosecutor's allowed to make those types of arguments because there is at least some evidence that was the case.
Yeah, I mean, they pointed to a couple of things of what they called skin slippage, which we didn't want to talk too much about, but just some things that on the corpses themselves could have indicated that.
And his DNA was in certain places.
Yeah, and there were some certain things, skin defects on the body, but unable to determine whether they were caused post-trauma.
The other issue that he raised that we really haven't discussed at all yet in any other prior cases is this doctrine of what they call corpus delicti.
Yeah, I thought that was interesting.
It's an interesting rule.
It's
an old rule. It dates back to English common law. And corpus delicti, I don't speak Latin. Most people don't.
But it is
but it is a Latin phrase that you learn in law school. It basically means the body of the crime. And the corpus delicti rule is one that says, in situations where there is a confession or an incriminating statement by an accused person, there has to be some evidence to support their statement, okay? So if someone's saying, I murdered my cousin, you can't simply prosecute somebody and convict them on the basis of the statement, I murdered my cousin. There's got to be some proof, however small, and it doesn't require a lot of proof, that the cousin was murdered.
Yeah, and we're not saying it doesn't require a lot of proof for a guilty verdict, but just to survive a corpus delicti challenge, right? So how it would work is, if somebody did make some type of confession, and I boil it down to this: you can't be convicted just on your confession alone.
That's right.
There has to be corroborating evidence, right? So if you say, your example, I murdered my cousin. Really, what was his name? I don't know. Where did this happen? I don't know. They don't even know what body to connect it to. There is no body of the crime.
And to be clear, they don't have to have even the body or the murder weapon or anything like that, but something to show that what you're saying has truth.
Yeah, and the other piece of it is that it kind of sounds like a homicide-only situation because it says body of the crime. You got to find the body. It really just means any body of evidence for a crime. So we see it in DUI cases a lot. We see it in domestic violence cases. There's certain things where potentially police officers get a little excited about a confession, think they got a case, and move forward. Most of the prosecutors get it at this point. They're just like, well, you got to have something else for me.
You got to have some level of proof. And so where it comes into play in Morris's situation, it's actually really interesting. It's also easy to resolve. in his case.
It's like,
But-
sounds like a really good
Right.
argument.
Cool defense.
Yeah.
But it really, the court resolves it very easily. But it is interesting because he is claiming, as it relates to at least 2 of the women's deaths, that there's no evidence of murder. Instead, that they died by drug abuse or drug overdose.
We alluded to this earlier.
And the medical examiner initially, as to those 2 ladies, had said that the cause of death was drug overdose.
And this was before he'd been arrested.
That's right.
He knew about any murders.
And then after Morris is arrested for murder, he then says, well, they died, through asphyxiation, by the sex during, or choking during sex. And then that evidence is shown to the medical examiner, that statement is shown to the medical examiner, and they change their opinion. They say, well, asphyxiation is not inconsistent with our findings, meaning it's possible that they died of asphyxiation. So he raises that issue saying, hey, this is a corpus delicti problem because, Morris says that they died from choking, and the ME then changes his opinion. So interesting, right?
Yeah. Because that is a frustrating thing to hear as a defense attorney, right? Just off the bat is to say, medical examiner determines one cause of death. But once we have a confession, we just match it, right? We just say, well, whatever the confession was, now I'm going to say that's how they died.
That's right.
Because they didn't really say that's how they died. They just
said it's not
rule it out.
inconsistent, right? Which is a lot of times you'll have scientific and experts who testify in that way. It's sort of a safe way to get to a conclusion. They say, well, that's not inconsistent with my other findings, meaning it's possible. So, he raises that issue, and the Court of Appeals says, okay, here's what the rule is. Like what you had said earlier, you have to have some independent proof of the crime itself. Something has to show that a crime occurred. And then they point to all of these other circumstances, the bodies that were in the alley, dragged from one place to another, the decomposition and the some of the injuries that are on the body, together with all other circumstances. And the Court of Appeals basically says, yeah, that was easy. There's corpus.
I mean, they found those people's items.
Yeah, he had some, some of their property in the trailer. His DNA's on those
security
things.
card and a bank card of one of them in his wallet at the time that he was arrested.
Right.
Certainly enough to tie him to those as murder. And I was going to go back. I'd forgotten kind of what I was going to say about that situation. So one of the things that he had said is that you can't argue. It's inappropriate to argue that I had sex with the bodies, right? Or to argue that Cory had done that because there wasn't really enough to prove that happened.
Right.
And they said, well, there was enough evidence, but the interesting part about it is that the biggest basis for that, again, going back to don't make statements without your lawyer, right? Is that he had made a statement to the police that when he had sex with these women, consensual sex, he wore a condom.
Mm-hmm.
But then during the autopsies, they found semen in the bodies. And so if you take him at his word that he was wearing a condom at the time, then the only way that got there, right? So it was just an interesting piece to say, well, you can't complain about that because now we're just using your own statement.
Right. And let's pause there for a moment. I mean, one of the clearly Morris's own statements were not helpful at all for him, right? I don't care which version you take. They died during a drug overdose. They died during this, a sexual encounter that we had. What's our number one advice that we give people? Don't say anything. If you are under investigation for a crime or suspected of a crime, or if somebody asks you about anything related to any sort of criminal activity, keep your mouth shut.
Yeah, and it's one of those where we're not saying it's so you can get away with murder, right? It's very possible under these circumstances. Cory Morris is getting convicted, right? Whether he makes a statement or not. But I think it really hurt him on whether or not he got the death penalty.
Yeah, because I guess moving in through the trial a little bit, of course, he was convicted at trial. He didn't put on much of a defense. In fact, the court, in their opinion, says he didn't present a defense. What that means is the state presented their case through all of their witnesses. The state rests. That means they are done presenting evidence for the guilt phase. Then it's the defense's opportunity, if they want. They don't have to, but they have an opportunity to call witnesses themselves. Morris's defense team did not do that. They didn't call any witnesses. There was no experts. There was no testimony from friends, family, neighbors, others, coworkers to corroborate. One of these defense that potentially comes to mind there, had he not opened his mouth, would have been alibi, right? I wasn't around. Those types of things. They didn't do any of that. They then move into the guilt phase where they go through the punishment, the aggravators that we discussed. And Morris presents in mitigation very little mitigation. Not a lot was given to the jury by way of mitigation to sort of counteract that possibility of the death penalty.
And sometimes, especially in like a very serious homicide where the evidence is very strong, it kind of just makes sense to not put on a defense. Or if the evidence isn't that great, sometimes it just makes sense to not present witnesses at that time. It's the defendant's absolute right not to present any evidence
That's right.
on their behalf, and that can't be held against them by the jury. Is it really, since they're human beings?
Don't you think in a capital case, I mean, when the
something,
death penalty is on the table, you got to do something.
But I guess what it comes down to for me is if that's going to happen, if you're going to say, look, we're not putting on a defense because it's just too damaging, there's nothing helpful here, we're just going to try to poke holes in the state's case, and then you read where they just time after time did not object when they should have objected,
didn't present anything.
That's where you got to be on it. I mean, that's what you're doing in that trial. Your defense in that trial is objecting when you need to object, and doing as good a job on cross-examination to call into question the credibility of any of their witnesses or anything that you can do. And I'm not saying they didn't do a good job on those cross-examinations. I have no idea. It's possible they did a fantastic job on that. But the other piece is you got to object and keep out everything you can keep out.
Yeah, it does raise the question for me, and this again is another issue that we haven't really dealt with. On direct appeal, you're only dealing with the issues that are in the record, right? What was objected to below, or any instances of fundamental error or the like. Direct appeal from a guilty verdict is not really the place to point out errors that were done by your own lawyer. There is a procedure for that. That's called a petition for post-conviction relief. If you go to trial, it's under Rule 32 of the Arizona Rules of Criminal Procedure. I didn't look at the subsequent history of Morris after the death sentence went down, but part of the reason why people complain sometimes that the death penalty, the post-verdict death penalty process takes forever. There's these endless appeals. One of those appeals is that petition for post-conviction relief, where you can then challenge and say, hey, my lawyer was deficient. You're saying I had ineffective assistance of counsel at trial. And again, it's hard to know exactly how the trial went, from a defense perspective. But these things, certainly the lack of objections, the lack of a case, the very weak mitigation that was presented, at least strikes me as something that in a PCR petition, you're going to challenge your counsel's effectiveness, right? And that is a way to get a new trial, have that verdict overturned. It's sort of a collateral way to do it, but it can certainly be done. I certainly would have expected him to raise that issue. Now, whether it was effective or not, that's, I guess, to be determined.
Not for us to
talk about today. But, that is the remedy.
Yeah. So... And again, I'm going to point out kind of the same thing, where almost every appeal is going to say that there was prosecutorial misconduct. Many PCRs are going to say that there was ineffective assistance of counsel. It doesn't mean it's a valid claim.
That's right.
And that's what the court would actually really break down, is information we don't have, that is the details of that trial.
Yeah, for instance, it would have been the duty of the defense lawyer to have an investigator run out and track down witnesses or evaluate. Expert witnesses may have looked at the evidence, and they've all could have turned up just nothing. There may have been no valuable testimony to present.
Maybe.
But as long as the defense lawyer did that investigation and say, I looked at every possibility and there was really nothing that I could do, well, then he's done his job.
Right.
Now, should he be objected and that type of thing? Of course, but is that enough to support an ineffective assistance claim? It may not be. It probably isn't.
And is it the reason he got found guilty?
That's right.
And is it the reason he got, the death sentence?
Mm-hmm.
It's hard.
Yeah, tough situation.
Yeah.
There was one other two issues that he raised on appeal that I think we can wrap up in pretty easily. We did talk about the photograph that was on the table. Morris also objected to the nature of the photographs that were actually presented. And the court looks at those from the same standard and says, well, are they necessary for the state's burden of proof? And are they overly gruesome? And so their only purpose is to sort of scare the jury or play on their emotions. And the court says these photographs are actually pretty tame. They were photographs, close-ups of hands and feet and faraway shots of the body. Nothing so egregious that it would have been alarming to a jury. And so that doesn't fly for him either. So he gets convicted. He gets sentenced to death. And he gets convicted of all 5 murders. He's on death row today in Arizona. Again, I look at it as kind of a really sad circumstance. Each of these victims led a tough life on the streets, and then murdered in a pretty sad way. Morris, challenging upbringing, challenging circumstance. Apparently a nice guy, but you know what they say. I mean, you never know, right? This guy.
It really stands for that. I mean, it's like, you got daughters, I've got daughters, you think somebody's a good person, you got to be very careful.
You got to check. Well, that's the Cory Morris case.
Look for that smell. That's
right. If boyfriend comes around smelling like dead bodies, it's time to get a new boyfriend.
A big red flag.
Huge red flag. Yeah. Well, that's our show for today. Appreciate your time. Of course, we want our audience to like and subscribe. We've never asked you to do that before, so we're going to start. Ring that bell or whatever it is. Smash that button.
If you find this interesting and helpful in any way, we'd love for you to subscribe.
Love it. Thank you so much.